Please go.
For many years now, I've been known as the rock and roll realtor. And since I'm retired from that,
You don't rock as much as you roll.
I'm not doing much rock and roll. I'm now the mental wellness realtor.
Very good.
Glad that Brian, come to the rock group. Come to the rock group, get your head together.
Okay.
We all need it. We all need to talk.
Very good.
Once a month.
Okay, now on a serious note,
That was serious.
the serious note is I've been working diligently to try to get some good training here, okay, at these meetings. Although I'm not getting the turnout that I should be getting. We need to get a little bit more people involved. So if you see your peers, hello, be here. I had a lot of conversations. I talked with the mayor on Saturday. I talked to the district attorney on Saturday. I've got some of these people coming in, so they would be embarrassing if I don't have halfway decent turnout. So we need to be serious because it's not a game. We're here to try to educate you and educate ourselves to be better. Not only in real estate, but in beautiful. It's just extremely important. Community is business. So if you please just talk to the other agents, please be here on 2 weeks. I mean, there's going to be a few meetings that may not be to your liking, but to others it might be informational. Okay?
Last week's meeting, Melrose went over a lot of new forms.
She did.
Are you gonna do any training on any of it?
There's going to have a lot of training to do. I'm going to be doing training again. I'm going to be starting contracts again. I was kind of doing this, disclosures again. But there's only some of, you get that line item.
Yes.
Yeah, so it's really easy. Okay. Some of the new issues who were not here, probably do. I don't think there's anything that's unusual. This time.
There's a lot of additions and
There's some additions, but they're
not loud.
Okay. Give it a
That spells on narrows.
I asked if you were gonna do any training on, any of the new forms you would do.
Is there one?
Well, no, no, Chuck was just talking about,
You just clarify. So with that being said, like everybody else, everybody's doing notes? Right? Nothing? Hello? Any general notes from this?
all I know is that the group is going forward. It sounds as if the first meeting in March is gonna be here at Realty Experts. I don't know if that's changed, but
It hasn't changed. The group hasn't still met with us except for one individual.
they have not.
Okay, I know, I'm still waiting. Have you heard anything?
I've heard we're trying to merge with another group financially, keeping the same meeting, heard that this morning. So I think we'll know more on Thursday.
Are you talking about marketing?
Yes.
Yes. That's all we know. As far as we know, as far as we're concerned, it's open, so. Okay, with that being said. Is it Diana or Deacon? It is Diana. It is Diana. It's It's now wraps up. And it was her that created this educational class today. And Vikki, which I just found out, she's the manager. Is that right?
Branch manager.
Right,
Fremont.
So she's kind of a big deal too.
And then you have an assistant, so there's two of them. It's good.
Yes.
With that being said, who's gonna take this one first? You?
Well, I really wanted to take 1 second to introduce myself for those of you guys that don't know me, that I've met since you the marketing meeting. Yes, I am the new Chicago Title Fremont branch rep. Okay, so I will be frequenting this office to assist you guys with any of your marketing and farming and anything we can do to help you guys succeed. That's what I'm here for. Thank you so much, Chuck, for inviting us today.
Wasn't going to chat.
Oh, no. Thank you so much. And so today we want to give you guys some insight in regards to probate, divorce, and death, how that affect your transactions. And I have with me, joining me, VIP, the branch manager, Vikki who's been serving realtors and doing escrows for over 10 years. So you've got someone with a lot of knowledge here. So we want to keep this really intimate and sweet, short. If you have questions along the way, please just raise your hand.
I actually have a question. And you must have been about 10 years old or something? Wow.
Fake ID involved.
Okay, so very quick little background. I do have, so we're two escrow officers and we have the assistant. So that's why I'm able to send you, and help you with the information because I have full coverage of the office. So you basically pay for tours. And we have Diane. Yes. So thank you so much for taking the time to be with us. Very excited. Take off with it. Right. All right. So if you don't mind speaking. Okay, so I would like to usually have this as an open floor type of conversation. We're gonna have a conversation. Basically, you have questions along the way, you ask me, I can share my experience, transaction I've seen. A lot of times I find out real situations, it's what helps people. Because you're not talking about hypothetical speech, you're talking about this is really happened in my transaction and how do we go forward, how do we resolve this issue. So I would like to ask really quick, how many of you in this room have done a transaction involving probate? Right? Now, divorce, raise your hand if you have divorce. Yes. Sales and death. No? Okay. This is very common, especially in a challenging market right now. This is, I guess it is like about 50% of the transaction we count. It's people passing away, heirs are trying to help the property, selling it, and disbursement funds. So that's why Diana put together this class is to help with especially the current market situation. First thing first, we want to talk a little bit about probate. And I think there's a lot of repetitiveness in this because we want to keep reminding our realtors. Anytime you have a situation like this, prepare yourself early, prepare to celebrate. Talk to your escrow officer ahead of time. You know, put a couple pointers. Hey, I'm going to my listing appointment. I have a seller who's deceased or going through probate or their successor trustees of the trust. So you prepare yourself, talk to the escrow officer, get a couple pointers. What can I do during my appointment? And then what information can I ask of my client? So this way your transaction will be a lot more prepared. You don't have to ask any surprises.
One of the things if you can follow that, what is a probate? When am I going to have a probate sale?
Okay, perfect. I love that. I love this. I love the questions. Probate is when you have somebody on titles deceased. They don't have a spouse or they're only entitled by themselves. If just for an example, you have a husband and wife hold the title, one of the spouses deceased, the other community property or joint tenancy, they're gonna automatically have property. They don't have to worry about probate. But you have a situation where both husband and wife deceased, you have joint tenancy, and you have heirs. That's why it goes with probate. Or you would have one single person on file, just saying, y'all know, very net source of her property or single man, then that transaction will go to probate because there's nobody else on title joining with this person. Even if you have a tenancy common situation where you have seller number A and seller number B, because the title is a tenancy common. So if seller number A is he's passed away, seller number B, since they're tenancy common, that person does not automatically acquire the portion of seller number A. So seller number A will have to go to probate. Does that answer your question? It's okay.
Okay.
So does that answer your question?
Yeah, I just want for anybody who hasn't ever had that.
Probate, I can say probate out of everything will be the most complicated one. That's very commonly, probate will get court, the judge have to give notice of probate, and then you have, and then you notice of proposed action. So these documents all required for closing. And I can share a list of what we need. We can collect everyone's email address and then we can email you the details of underwriting requirement, which I can go through very briefly with you. We do need a certified copy of letter of registration to be reported prior or concurrently to the client. And number two, title will require a copy of order or probate. And then the third one you need is notice of proposed action. And usually for the notice of proposed action, they will give you time, like you have 20 days or how many every days, and you probably cannot transfer until it reaches that. Okay. It's a statutory time period that's required by law. And then if you have closed escrow prior to the date, then we will require consent or waiver from all heirs. And 15-day for proof of service. So, if you have a situation, okay, I really need to close this transaction, and then the probate on the notice of proposed action said you cannot close the transaction until, let's say, March 10th. But due to any situation, we must close escrow at the end of this month. What title will require is all the heirs listed on the probate, everybody be able to consent, written consent, email consent where we can identify the email address and we can basically confirm that everybody's on the same page. There's nobody coming up to object. The whole reason for that grace period is so nobody comes out of the us and you have a probate and none of the heirs are going to be tested. Sometimes you may have a relative that's not going to deal with. They may not like how much money you're going to get funded. So they may become an obstacle. And for that being said, that's the whole reason we set the state. So give people the time to review the document, to confess if they have to. And then the fourth thing that title requires is a comfort letter from attorney after the date of the notice of proposed action. This title wants to make sure that the attorney is well aware of the situation, and then they already have all consents and waivers and whatnot. And this is something the title wants to make sure there's no objection. So that's why when you do probate, when you have an attorney involved, it's much easier. And we do suggest that our client connect us with that attorney. A lot of times I know you're trying to help and you're trying to relay the message to the attorney, but we don't want anything to be missing, and then it's creating more job for you. So what I personally like to do is when you have a probate situation, I don't care how complicated that is, then hey, we need this transaction for probate, this is a probate attorney's contact information, and reach out. So we'll connect with them directly, give them a list of who we need, and then we'll work with the attorney to talk about success.
Marie, could you just repeat real quickly the three? I have the last one, which is the notice of proposed action. What's supposed to?
So we need a certified copy of the letter of administration. This document will have to be reported concurrently to the deed to buyer. And then we need a plain regular copy of the order to probate. And the third thing we need is notice of proposed action. And the fourth thing we need is a comfort letter from that person. Email's fine, a PDF copy is fine, as long as it's a letter from a comfort. No, I can send comfort, yes. And then they're comfortable, comfort letter. Yeah, that's what we call a comfort letter from the attorney. And then Diana will put this together for any of you who needs those detailed information. Some of you may have a client you want to see that you're interviewing, they may be. So connect with us and help us.
Vikki, on the average, how long do you think, or would you say it takes for all this?
That's a really good question. That's the second thing I was going to go into. When you have a probate transaction, do not do a 7. So, it will happen, but try not to do a quick one because it's really depending on if there's any heir object to the situation. It could be lengthy. I've seen probates up to 180 days because one of the heirs they can apply. Of course, they have to serve them, they have to connect them, they have to show proof how you're communicating with that heir, whether that person received it off. So depends on, I would say depends on the size of their family. Sometimes you don't know. Some probate may be easier. You only have to have it already. And some probate, you might have 5 siblings with 10 grandchildren. So those situations may become a little lengthy because just the time alone contacting everybody, finding them help, they go where they live at.
And maybe this is a silly question, but how do they go about finding homes? And just as I hear this, I'm like, okay, I don't have kids, I'm not married, but you start going to my outer banks, and there's a ton of people, so.
So this is what I heard from an attorney that worked with. This is not something solved because as one Ron and John did to this. What they will do, they have a program which they can search, like family search, and then they can find as much as they can. And then what they will do is when the reason the probate is very lengthy is they'll have to put on newspaper, or they'll have to go through some sort of communication to make a notification, hey, there's a this person, contact us. Okay.
So what happens to the buyer and the buyer's agent? A lot of time we see some probate sale and there's not going to be any extra expense. That's the only thing we look at. So as the buyer's agent, do we have to ask any question?
So this is a very good question too. That's the whole reason you need title company because we are the state law employees. We are the ones that go through the writing, making sure that nobody after close the transaction is going to come and challenge this transaction. So for the buyer's agent, all you have to do is make sure we do have title company, we have approval. How far are you? Like, which part of the approval process are you? Are you missing anything? So you can also, present this list and say, hey, most title company levels need this information. Are you ready to have all these? Yes, or this. So this is something a little tricky. When you put in an offer, I would say check with the listing agent how far they're at with this probate. And so this way you can get it directly from the listing agent. Because there are documents that title company may not be able to provide to you as buyer's agent or buyer. You can always check with the listing agent. Hey, this is what normally title company wants. Do you have everything? How long do you think that it will take to apply this document? And an attorney, well, the realtor showed his age from an attorney, did a realist have like, hey, is it filed? But we will receive it because there are documents here. We need to record confirm, so we know which. And sometimes we encounter it because it's been filed. The attorney requests a copy, they haven't received it. So they will have to either pick it up, request it by mail, and send it to them. So there's a little bit of that. Okay, and well, if that is that's what we can sustain. Because if you have an attorney that's not responding, you have a attorney that's challenging. Because I encounter a transaction with attorney that's overwhelmed. That's not the whole situation. When they ask them document, they don't have this and they don't have that. So ended up they say, hey, you know what? Your title company is asking a lot. Let's switch your title company. And they switch to different title company. They're asking essentially the same thing, just in different wordings. So then the seller found out the attorney actually messed up the situation and some documents not filed correctly. Seller got pissed off, went for a second attorney, which the second attorney chop. We got it because it's already started. So it's like you're carrying the transaction. Of course, they were charging already, but they actually got it done with it. Yes.
Are you still on probate or have you got into divorce yet?
We're still.
Okay, good. I just wanted to throw something out there that I learned doing probates. That when you're working with your seller, to advise them through their attorney to make sure they get full authority and not limited authority. Limited authority is a pain in the butt, and that's how you can have. I had a deal going on where I had double-ended my probate. But I didn't realize the difference between full authority and limited authority. And limited authority, they accept bids at court, and we lost it. And so, if you have an option, I would suggest talking to the sellers and make sure that they impress upon their attorney to get them full authority. It takes a little longer, but it's worth it.
That's very good. That's how you can tell your attorney. So, partially by transaction attorney and get all the actually putting They don't tell us a lot, but I can only share what I heard from them.
I asked for when you need to refer this as well as the
Unfortunately, we cannot refer it, so, that's industry thing, yeah. Like, we don't take notes of who we work with, but that's actually good to know that. Next time, of course, when I encounter them. A lot of them are out there. Yeah, we work with a lot of them out there. Nobody actually have to go to office, it's really. So, we, the, we have done that with each other.
We would tell you specifics, better, we would give you attorneys who worked with in the past on, so. Okay, moving on,
Moving on to divorce,
and so,
okay, divorce is the next biggest issue that we have. Normally, it's not complicated if you have a board very cordial. When it becomes nasty is when peasant wives fight, who gets what? I don't wanna talk to you, I don't want money to pay, This is where, escrow range issues, when seller will tell you, I don't wanna give seller to settle. Seller choose like, I don't even want to send property until he gives me one rent. Then, those kind of cases, I will say, your realtors all know, just like escrow, we can get involved. If they have, an attorney that they're working with verbally, we can work with attorney, implement with attorney. If they have divorce decree ready, it will tell you exactly how the property is really working. So this is where you need to, we're gonna have a client that is going through a divorce or already divorced, make sure he's going through divorce escrow. Only the part that changes how the property is moving. Even though escrow cannot enforce it because it's not a court order, but at least it's a reference for us. That when you're doing a closing statements, you will have a seller, they are pissed off, saying, what? My divorce decree said I have 70% of escrow on the board. So communicate with the escrow ahead of time, gives information. And number two is when we have seller, both have attorneys involved and they can't come up with that meeting. And seller not coming up with an agreement, how to direct their plans should not affect those escrows. You can't do it because seller cannot decide who gets what. Let's delay closing for a day or two. It's controversial, we have to follow the contract to close on a certain date, unless both parties seller agrees. And we have seller telling us, hey, can you check, can you hold funds cost? And then that's a huge no, but it's not full fine. Escrow cannot hold seller's funds just because they can't decide it. But if they have an attorney trust account that they set up, which we range a lot, we can transfer the seller's proceed to an attorney. Doesn't matter buyer or sellers, as long as it's in the attorney account will pay in their account disperse and their rent. This is a huge question in the past from all real estate agents and sellers. So when you talk to your sellers and you know that they have a divorce situation, you probably can get a sense if they're for you or not, and then you know the direction you're gonna. I mean, they can't talk to them if they have attorneys involved. Again, let the attorneys know. Have the seller talk to attorney. We can't delay escrow just because we don't agree. Let's negotiate with the other attorney that's set up a trust account, and we put the money in your account closing. And this way, even if you take the 7-10 day cash closing, you shouldn't affect it. Otherwise, we have seller that refuse to sign because they can't come up with an agreement. And then it's a closing, buyer gets mad, buyer sues the seller, or buyer wants money because they're in a situation that moved on. So this is something for you to think about when you're not with those things. Okay. Is there any questions?
yes. So again, on the buyer side of it, if the buyer is, going through a divorce or and one of the buyer is buying the property, what is the type of need for it?
So this is a good question to ask. When buyers go through divorce, they're not completely divorced yet. So if buyer has been just stay untied, lender and escrow will be part of this process as important from being off. And unless you're finalized on the divorce, otherwise we do require responsibility to sign. by the other spouse.
So basically, quick,
Yeah, we use the interspousal because when you're still married, the interspousal is in place.
so just by signing one party, then.
That's basically, they said they have nothing to do with properties on it. And when you have this kind of situation, to find out for me, I had a couple of transactions last year because the wife or the husband does not want to sign the interspousal identifiers. One of the transactions fell apart. Lenders like, we need to sign. Wife got a lot emotional because I don't know their situation, but we are very emotionally divorced and like, wife's like, why are you finding out in the month? I do not, we're still legally married. If I don't sign, we can move forward. Here we go. So yes, we had a transaction canceled. We were 2 dogs. But hey, wife doesn't want to sign. Yes.
That's really important because as a lender, they get that all the time, going through divorce. Oh, he'll sign a quick claim deed, and he doesn't at the end. So and I had a very, very experienced agent who wanted us to process it that way, and I just said, you can't start it unless you get, this guy was not helpful. And they ended up having to wait a year and a half before they could buy a house. So it's really important to have those conversations, as difficult as they are. You gotta make sure that other person's on board.
What is it called? Interspouse.
Interspousal.
Interspouse.
And communicating is the key. Communicating with your agent, communicating with your buyer herself. In your case, communicating with buyer. Make sure, and if you know that they're ready to sign, to wait, let's go know. We can schedule the wife's signature and husband's signature ahead of time too.
Like even if the property is not in place, they can.
Oh, no, the property has,
Yeah.
you have to be in contract first. And normally we suggest when the contingency is removed,
Yeah.
that we can proceed with the signing. It's better, otherwise, in case something happens, transaction cancels. So once the contingency is removed, we can just have the spouse sign early. Or the spouse looking.
Can we have you sign before the kid?
We can certainly sign, it's just a lot of my clients process this way is because in case of something.
I would say you should do it as soon as you possibly can.
And then I'm pretty sure lenders on the same page, because we have transaction where lender actually have no clue and come to argue with escrow. It's like, well, can you close without it? I said, don't check with me. You check with the underwriting, your loan document will well have a clause on there. If they're married, we need interest also, that's kind of going to stay. Unless your client decided to tell you on the loan app saying that I'm married, then hey, we're not please, we can't do anything. And then in case some audit comes down, we're not liable because lender and escrow, we take instruction. Document, they're basically sending independent to perjury, the information is supplied to us accurate. Okay. So divorce, another thing, divorce is the second big thing, and another one which we commonly see is trust, family trust. You will have successor trustee. The parents pass away or grandparents, and you have someone successor. So whenever that's rule of thumb, because I have a client ask me all the time, when this kind of company is a wholesale seller's trusting, we normally typically don't use it if there's no chain of trusting. Just say Jamie and Jen, they are both Jamie and James. They're both on titles as trustee of the Jane family trust. Nothing's changed. You have no successor trustee, nobody giving up their signing authority. We don't need trust on it. We just need client to sign trust each of us. It's very easy. But you have a situation where one of the trustees pass away, or you have both trustees pass away. That's when we need a whole set of documents to title splitter review and see if they are if to sale. And if there's we should want to out. And to decide who is the legal authorized person to sell on the file. So this is the legal splitter. And when you have a successor trustee of the transaction, you gotta make sure that they obtain 10 of trust. We have a lot of clients, they have to apply that last minute because they are not aware. We can use their personal, social security number so that affect their tax reporting. Nor we can use the deceased person's social security number because they are no longer alive. So the trust must obtain the trust ID.
How do they get that from the bank?
They can check with their CPA. Yeah, or there's a portal, they should be able to find that. And the second thing is we cannot send funds to the successor trustee account. We get asked a lot, okay, I'm successor trustee, sometimes we know we cannot. Title company has to release the proceeds of the sale to the vested owner, which is James Family Trust or Regional Family Trust. So make sure they set up a trust account. And they can take their trust document to enter the bank and the bank. Those are two things. And another thing which came up a lot last year is we are looking at the word we're looking as well. Looks like our county is very desperate and they're very poor in loan. We've seen our county a lot, so that you know. Anytime title company or our seller goes to report a successor affidavit of chamber trustee, the county will use the property. We have seller transactions closed, 2 months later, they receive a text. They're asking us what that is. And we ended up having a call and we found out because the affidavit of the trustee has been reported. They are assessing the property from the day of the death of the deceased. This is something we learned. We haven't seen them, we don't see them a lot. We have not so far seen anything from Santa Clara County, San Joaquin County, but Alameda County has been doing that. Within the last 2 months, we had 3 transactions seller call us and the final goes on. And either client will reach out to us, we don't know, but if they reach out to us so far, it's been a 1-4 Alameda County. And that's how we learned that county is getting a little desperate. They're trying to attempt to it and control it. So we did ask the county, another thing is how do we get that? So county did say there's applications, they have to talk to the county and get the application put in prior to transfer. If you already recorded me, there's no way to go back and apply for an exemption. Because we told the county technically it's still a trust that is fully titled. So we're trying to argue with the county, you know that, that's why I'm the problem. Arguing with the county never works. The county said it doesn't matter, they record this affidavit from trustee. And this is something to think about. If they haven't reported anything, make sure they have to on the county to see how to apply for an exemption. If they already reported it, and already we have to see if we can wait or review. It's something. Yeah, it's very new. So 3 transactions within the last week. Yeah. So not having one of some of that stuff on 18,000 a little both of them. This probably is very expensive. And they assessed it from their debt. Which is years, which is last year, and probably doesn't. So the other thing that we, a lot of people contact us and ask us, transfer of destiny. I have even our agents who's trying to figure out how they gonna help their kids when if they pass away, what's gonna. And our agent comes to me and asks if they be trusted and they trust social media this. This is very popular, seems very easy. Even though I cannot give recommendation suggestions, but from our underwriting department, not only from Chicago. My history, I worked with Fidelity. I worked with customer panel or TV and I started on Fidelity. All title companies requirements are like the same for the T-O-T transfer from this. Because this deed is so vague, it doesn't have a lot of information. There are a lot of people becoming in the middle of transaction challenge. Even the transactions completed, they get challenged in hey, how do I know that this person really signed this deed with no resources? Are they willing to sign it on the state? Are they going to influence? So these are things that's very easily challenged. That's what kind of companies so lucky. And those transactions are always case by case. we have to look at the document, and some of the document that we will need is if the client has a will of estate planning before they go to probate, and to not do that in probate, to probate all the supersedes TOD because this is a very complicated topic. And I don't like to get into it, but I have to because a lot of clients that's been possibly for I'm taking a mistake. So, okay, so let's be about the seller maybe giving some action. Oh yeah, they have a TOD that knows we reported like a month ago and some assistance. I was like, okay, let's stop right there. Do you know their relationship? Caretaker. So the TOD was signed a year ago to a caretaker that was taking care of the elderly for the past 4 years. Do they have kids? I don't know, maybe they do. Why is it not given to the kids? Are they under the influence of medicine? What is something? Well, because the seller said that the caretaker is really nice to the caretaker claims. Because I take care of him, the kids stay next to him, so the seller told me that I need to for this because funds effort that's better. Okay, is it how did it use? See, a lot of questions, even you guys looking at you, like a lot of questions, okay, how did it use? How do you know that this is legitimate? How do you know that nobody's gonna come and challenge this transaction? There are realtors there, there are realtors there they cannot talk the transactions, it's a lot of real training. But for you, that's in this business for a long haul. You want to consider your license and you want to consider other matters too. Something happens, yes, the buyer sues or the seller sues. Now, yes, we heard it, but they didn't go to their realtor too. It's like, oh, I didn't know, my realtor city. And they just went on a title company to that, right? And we're here to prevent that from happening. We want to see how we benefit and how we go too. For TOBD, some examples I'm going to give you that you're not going to like because I will want to know their family tree. Do you have siblings? Does the deceased person have heirs, first and grandkids? Does the siblings, their uncle, auntie, do they have any parents that are alive? How do you justify that person or this title from the TOBD and it's really past something? So there's a lot involved in kind of needs to see. And on top of that is when you have TOBD done, just say husband and I, they sign 2 separate ones. I choose to give the property to my daughter. And maybe my husband is like, no, I want to give it to my brother. So we each sign our TOBD, but we're outside of this joint tenants for the property. What happens is, I die from what he did. And the TOBD I signed is no. It doesn't have any effect because of the joint tenants. When I pass away, that has to automatically property. So when he passed away, his TOBD is the one that we should. So if you have this kind of situation, make sure that the latest set TOBD is the one that we have to use. So these are the examples I'm giving for are all questions I have developed last year also. That because the TOBD section of the yes. What is the full form? What is the full form? The full form, the TOBD is actually called the transfer of debt. So TOB.
And in the same situation with the buyer, so they take buyer property, which was has the same situation where the seller gave their property to not their kids, but to the caregiver. The escrow closes, the buyer acquires it, no issue.
If there's escrow, if escrow is closed, I have to pass it, then you shouldn't have the issue.
Okay,
Yeah,
but
so that's why
they
tax insurance is covering. We already brought out to diligence.
We didn't make it. Yes, but now they are refinancing and they found out that the taxes were not paid.
This is a tricky one. Their taxes, meaning that, which part of the taxes?
I don't know the details, but I heard that they were refinancing and they saw that some of the taxes were not paid. So again, I am I'm not too much concerned because they are getting a fee and their title.
Yes.
So they should be concerned about that.
But there is something, because if the taxes were issued after the close of escrow, then wrongful title company don't get involved. Anything issued prior to the close of escrow, this is where we prorate. This is where we come up. If issued after the close of escrow, the tax documentation will actually tell you what period of time does it cover, and it will reference, how did it come up with it? Which transfer are they referencing to? Just say that the TOD is that, TOD doesn't come in effect until somebody passes away. Just say that there's a transfer deed that November of last year. And your buyer acquired the property December of last year. And the closed escrow is maybe the end of October, right? So they will tell you they're assessing this property based on the transfer that happened on which date. And the buyer can do is based on that date, they call the county and request the county to reallocate the property tax bill. That's county's way of rating the property tax bill, that's how they issue.
But it's not gonna come to the buyer, right?
It's not, but then if it comes up on your, shows up on the freelance, then make sure you have the actual bill. They will tell you that this assessment is based on which transfer date. Then the buyer can look at, this is not my transfer date, this is prior to my transfer date. That's when the buyer can call the county, and sometimes you just have to point it out, because county, they don't automatically. You call them, let them know, hey, I acquired my property December 2nd, and this bill is based on a reassessment based on transfer event on October 2nd. So there's 2 months of difference, right? So the county will reallocate the bill, they'll sell the portion of the seller, whoever they find seller, and then they'll send the remaining balance to the buyer. So that will be the buyer's responsibility. I have a current refinance transaction going for exactly the same thing they go with.
So it's not gonna come to the buyers, but the seller is still alive. So it will go to the seller or the partial company.
So this is when title company doesn't get involved, because it happened after that as a escrow. That's why we are letting the client know when they come down, what's fast, how fast. A lot of clients don't know how to explain to them what they want, but it's called reallocation of the tax bill. And you just point it out to the county, my transfer happened on this day, and this bill is issued prior to the type transfer. County knows exactly what to county, and then just request the county to reallocate it and move buyer. So the buyer will only be responsible for the amount after this.
So if I have to tell my clients, basically I have to just tell them the date of that.
Of the transfer, and then you look at the bill itself, they'll tell you when they're assessing the property, like based on which day of transfer. Yeah.
I've been around a long time and have never heard of a transfer deed of death. Is that what's
TOD, transfer like that. Transfer on death speed.
Okay, so if we're talking about sellers still being alive, how could that even be?
If the seller is still alive, then transfer on death speed is to basically we don't need to, even though they reported it, and there's a survey purpose.
Right.
Yeah, so the first thing, like when we review the title report with a title officer, when we see a TOD being reported, the first thing we ask the agent, hey, sorry to ask you, is the seller still alive? They're like, oh yeah, seller's alive. Then hey, he's an item out. Good. We have lenders coming to us, it's like, can you remove them? I said, our sellers alive, technically, we're ensuring those will be removed, those will be accepted. These are not necessarily available. These items may be removed, so we don't have to worry about it. We have to do some sort of explanation sometimes to the lender, because when the lender sees it on the print, they don't like it. But based on the seller still live, we can complete the point. The only issue is when the sellers. And then I don't think I've ever had a lender that's able to take a refinance transaction with a TOD, because we actually last year I actually opened a refinance. Same situation, end of that transaction, that seller took the transaction with a different lender, nobody wants to it, nobody's able to do. Because
You want insurance.
because title company want to insure it, and lender cannot, like, for you lender, be able to lend the money to the seller, you have to be to the owner, you have to make sure this is the Right. And then the lender, first thing, when they see TOTD and when we found out sellers is these, we can get all the documents we need. Those are not technically best the seller that we just have to. And therefore, the lender will not be able to continue the loan and then therefore kind of probably that's it.
So do those TODDs work?
That's the thing is they choose case by case. Out of all these years of working in this industry, ever since it's became popular, I've gone through one transaction. They had everything. They have a very small family. The brother acquired the property. Sister doesn't have any hair, doesn't have any kids. And then only 2 siblings involved. Other sibling agrees. There's consent that is yes, they agreed to sell the home. So that was not because they have such a small family. So TOD does work, but it goes through a very extensive kind of underwriting just to make sure we're able to ensure a new buyer very clear title. But once it's insured, then buyer doesn't have to worry about it. Yeah. Okay. So we kind of already talked about very important issues that we see in seller situations. Do you have any questions? Any questions in regard to any of the topic we just talked about? Probate, sale, divorces, TOD. Unity is not strong. So.
In order to avoid probate, if you live in trust or
Yes.
do we trust
Or will.
and also for confirmation, sometimes you'll have that.
Yes, for probate, we always have to have. Like the letter of administration, they were all issued with the order of probate, they're all free. All these documents are divorce plan. Yes, so when the living trust is what I have a lot. This is the only thing I think is safe for the sellers if they plan with probates. I have a realtor that we were chatting, it's like, okay, I'm getting old. We've seen it a lot. In terms of time, what's the easiest way for you guys to prove ourselves? Is it gonna be a will? Is it gonna be TOBD? Or is it gonna be a family business? I said, even though I cannot give you recommendations, suggestions, but with the trust is the easiest way to us because underwriting what just looking at trust document and decide and to underwrite to make sure that successor trustee, so on and so forth, and not. If we have multiple successor trustees, we may require small to sign. If somebody wants to give up that, they can send us. They can specifically send us a letter addressing to the company and state that they are aware. So I'm supposed to sell the property at the price. They are not going to be involved in signing. And there are situations where we have a successor trustee coming in and then trying to avoid this. It's like, oh, I don't want this person to sign. I want that person to sign. That's huge red flag. Once we have this kind of situation, power companies normally make wrong beneficiaries to issue a statement. Just to confirm, everybody's on board. We all acknowledge that's the way it's supposed to be signing itself, document. So when you talk to a seller, if you have a set site seller, they have this agreement. So once they want to sell your business, there's that net value. That's not as the person that's in charge of signing may not have capacity to as a meeting. So these are all valuable information for the time. So we can let you know what we need, what we look for, and you can select that first. You don't have a situation where you're based on closing, so it's going to be like maybe, I don't know, some of the issues. Then you have the buyer's agent you gotta talk to, you have a contract you gotta talk to, you have a lender that may have a rate violation, so it's a little bit late. And we do suggest the communication with their title and as well with their SOS. That's what we're here for. And you see, I'm like, well, I keep on repeating that because this is something a lot of clients do, which causing them to make problems because you don't have to look at the issues of this. And I'm speaking for myself and for our officers, work with us. All right. we're wrapping up now and we're up hour, but it's at the end of the day, I think that's why it's important to have a great relationship with the title company. I know that you can come to them and communicate any of your possibilities, scenarios, brainstorm ahead of time. So I encourage you guys all to, you know, stay in touch with us, whether we're working with you or not, we're always here to help. If you have a question, don't hesitate to chat to them, if you're fine. And we can always brainstorm, because the point is, you know, probably cool value because it's going on, or make sure for us to go on. Anybody else have any questions for us? Or you wish to roll it up for the day?
Hearing none, thank you, everybody.
We have lots of resources and tools as well, and I'd like to get you guys connected. Okay. Thank you. Thanks, Scott. Thanks, Rose.
Okay.
Yeah.
Now we'll start with the announcement as well, and there's no meeting next week. There's a holiday coming. Yes, no?
We don't have a meeting on Tuesday, however, we're gonna do a potluck. So I do a company potluck, meaning bring a dish, your favorite dish, share. You don't know how to cook? Oh, sorry. So we'd like to just have a, you know, a fun little network with each other and just get to know each other and celebrate Chinese New Year. That's also, you know, fun. I think it's 11:30 to 1, would that work?
Yeah.
Okay, so we'll have a sign-up sheet at the front desk, so if you could just sign up what you're gonna bring, that would help us. Okay, okay.
Thank you. Okay,
Thanks, you.
anybody else have anything, any general announcements?
General,
Oh, yes.
can I, it's a little bit of a commercial, but we do have a 5.875 0.30-year fixed rate loan up to $2 million. So that's pretty amazing, and you can get that 7-year at 5.375 if you want to go to 7. So I know that we have a lot of jumbos around here, and this is anything 8 to 6. I'm not thinking. Oh, March 17th.
What is that?
That's going to be net sheets for buyers and sellers. And if you don't know how to do the net sheet, we'll always do it for you. But if you're stranded on a desert island and need to know how to do it yourself, I would highly recommend that.
Good. Very good. Thank you so much.
Has the market changed? Because I'm looking at a lot of, all of a sudden, pending sales and.
While you were gone?
Well,
Yeah.
multiple offers.
Yeah.
They had.
Yeah. It's gotten a little bit better. You haven't tried a little bit higher.
Yeah,
But sales have been pretty good.
yeah, a lot of people coming.
With under 6%, what they've been selling.
Just want to mention on the marketing meeting,
Buyers.
when I first started, you were getting like 30.